Hello, everyone. This is Demetrius Peterson, attorney in Husch Blackwell's Higher Education Group. We are excited to give today's presentation on understanding constitutional issues involving religion in higher education. Before we begin, I would like to cover a few housekeeping items. At the bottom of your audience console are multiple application icons for your use during the program today. I would like to take a minute to highlight a few of the key icons for you. If you have any questions during the webcast, please submit your question via the question box. We will try to answer all questions during the webcast today, but if a fuller answer is needed or we run out of time, it will be answered later via email. We truly appreciate audience participation and encourage you to submit questions throughout. If you have any technical difficulty, please click on the help icon. It has a question mark and provides information regarding common technical issues. A copy of today's slide deck is available in the resource list icon that looks like a folder at the bottom of your screen. This program has been approved for Colorado, Illinois, Indiana, Iowa, Missouri, Nebraska, Tennessee, Texas, and Wisconsin continuing legal education credit. To report your hours in Illinois, Indiana, Nebraska, Tennessee, or Texas, click on the CLE widget at the bottom of your screen and complete the questions. A recording of this webcast will be available tomorrow for watching and sharing. Once available, a link to the recording will be emailed to you along with a certificate of attendance. The recording will be available for 2 weeks. Presenting our webinar today is Jordan Alt. Jordan is a partner in our Jefferson City office and litigates product liability and toxic tort cases for many of the world's leading manufacturers. He also helped launch the firm's nonprofit organizations and religious institutions team. In this role, Jordan has advised nonprofit and religious clients on a variety of issues, from litigation and employment disputes to tax and real estate issues. And so, without further ado, Jordan Alt.
Thank you so much, Demetrius. Good afternoon, everyone, or good morning, I guess, depending on where you're located. I am tickled to see so many people on the attendee list. This is a topic I'm passionate about. I think it's in the news quite a bit, and I assume it gives a lot of you a fair amount of heartburn or sleepless nights, so I am happy to jump in and discuss it. At the outset, we've gotten some questions about whether this is geared at public schools and universities or private or both. I will say at the outset that most of the litigation and the cases that we're going to be discussing involve First Amendment issues. So they do involve public schools and universities. But don't hang up if you're with a private college or university. A lot of the issues will pertain to you. They'll pertain to you in slightly different ways, but I think it's good for you to be on here. We'll be going through a lot of lessons learned that I think will pertain to all colleges and universities. And for what it's worth, although the First Amendment applies to students at private universities, it applies in different ways. You'll need to stay abreast of your state laws. You'll also need to be aware of your own institution's policies and procedures and how they might differ from public institutions. Obviously, we can't get into that many institution by institution details, but I'm hopeful that everyone on this webinar will walk away with this with some good information. So I'm going to be talking about law, but also stuff you're not supposed to be talking about, like religion and politics. So I will save you the problem of Googling me to determine whether I am worth listening to and give you a little bit about my background. I'm the product of both private and public education. I went to Illinois Wesleyan University, go Titans, and got my JD at University of Illinois at Urbana-Champaign, go Illini. Also, since we're talking about faith, I do come from a faith background. I'm United Methodist. I'm actually married to a United Methodist pastor. And I should say that I do legal work as chancellor for the Missouri Annual Conference of the United Methodist Church. So I stay abreast of a lot of religious issues like those that I'm going to be talking about today. So let's jump into what we're going to be discussing. And at the basis of everything is 16 words at the beginning of the First Amendment to the Constitution. Now everyone knows freedoms of speech and freedom of all the various freedoms in the First Amendment. We're going to be talking about the two religion clauses in the First Amendment. And this may be a little elementary for the lawyers out there, but bear with me. The first two clauses state, Congress shall make no law respecting an establishment of religion. It's what's called the Establishment Clause. And it continues, or prohibiting the free exercise thereof. What's called the Free Exercise Clause. Essentially, what the Establishment Clause means is that government actors can take no actions to support one specific religion or all religions. And the Free Exercise Clause basically says, government bodies, you ought to stay out of people practicing their religion in whatever way they see fit. Now, these seem to run parallel, but there are often times where they can be in tension. So before we jump into the higher education aspects, I want to talk a little bit about the litigation we see in religious constitutional issues. At the top here, you will see the big cross in the public square. You'll see the 10 Commandments at the county courthouse. These are the kind of Establishment Clause cases that we see again and again by putting religious iconography here. Usually it's going to be Judeo-Christian iconography in a public setting. Is the government essentially violating the Establishment Clause? Sometimes yes, sometimes no. Those are really fact-driven analysis. But I should note that these apply to public colleges and universities as well. Think about your campus. Obviously it's a different thing if you are at a private or religious university. But if you're at a public university, if you have religious iconography displayed, it's important to consider. Is that a violation of the Establishment Clause? Now again, it's fact-intensive. Courts may look at how long it has been there, why it's there, whether there are any religious services associated with the cross or the 10 Commandments or whatever iconography may be there. And the biggest thing is, are public funds used for upkeep of the cross, of the 10 Commandments, whatever it might be. So those are typical Establishment Clause issues. We also see Free Exercise Clause issues in schools, K-12 and higher education. There's always debate about prayer in public schools. There's debate about commencement speeches or prayers that are offered during commencements. For what it's worth, courts are much more lenient in allowing prayer and benedictions at commencement services for colleges and universities than they are in K-12 settings. And they're also much more lenient if the commencement service is optional. If it's mandatory, it gets a little trickier. But it shows how there can be a struggle between the Establishment Clause and the Free Exercise Clause. Schools want students to have free exercise of their religion, but in doing so, are they essentially violating the Establishment Clause by promoting a religion? It's a tough question to answer. And in the bottom right, you also see that is a sanctuary from the Church of Marijuana in Colorado. Oftentimes courts look at the Free Exercise Clause and determine, well, what exactly is a religion? What is the free exercise of religion? What does that mean? Particularly if the free exercise of religion involves violation of the law, use of marijuana, use of peyote, animal sacrifices, and on and on. Hopefully you're not going to see too much of that in a college setting, but at least as far as animal sacrifices. But those are the kind of issues that we see. Some of them you may see on your campuses, some not. So we're going to jump right in and move to the education setting. How I'd like to walk through this is to dig into 3 legal cases, 3 judicial decisions. For each, I'm going to talk a little bit about the facts of the case, but mainly we're going to focus on the result of the decision and how the judge or the court arrived at that result. And then from there, we'll talk about some lessons learned and next steps that may impact you as an administrator of a private or public college or university. Now, the first case actually involves not a higher education institution, but a K-12 school district. I know, but this is a really good case. I use it to teach this issue, and I think there's a lot of good here. The case is American Humanist Association versus Douglas County School District. It is a Colorado case. The American Humanist Association, the plaintiff, is a nonprofit organization that promotes, quote, the separation of church and state and the constitutional rights of humanists, atheists, and other free thinkers. And the individual plaintiff, Jane Zoe, is a member of that organization and a mother of 2 young students at Cougar Run Elementary School in Douglas County, Colorado. Now, at the outset, I will note, if you run into the American Humanist Association, or if you run into other organizations, another that you'll see quite a bit in this litigation is the FFRF, Freedom from Religion Foundation. Those are nonprofits that often try to push the separation of church and state through litigation in the court systems. So if you see those organizations, no judgment on those organizations, but some alarm bells might be ringing that litigation may be in the future. The defendants in the case were the school district, but also the members of the Board of Education, the superintendent, and 2 principals, which brings up an important point, a point that a lot of you may not want to discuss, but the situation is oftentimes individual administrators are named as defendants in this type of litigation. It's not fun for anyone, but it's something that you should be aware of. So what happened in the case? The plaintiffs claim that the defendant school district promoted a culture of promoting the Christian religion within the school district. How? This involved a 2014 mission trip in which 14 students from the Fellowship of Christian Athletes and 2 teachers traveled to Guatemala. The trip was planned by a company called Adventures in Mission with a stated goal on Adventures in Mission's website of promoting Christianity and introducing children to the Bible. Now, at the outset, I will say that there's nothing wrong with this in and of itself. Public schools can and do have Christian organizations, Christian student organizations. They can take planned trips like this, including mission trips. So let's continue. Prior to the mission trip, a 6th grade teacher volunteered to spearhead a supply drive, which lasted 1 week during school hours. The teacher printed flyers that were sent home in the students' take-home folders, and the flyer stated that the supply drive was sponsored by the 6th grade class, partnering with the FCA, born out of a desire for our 6th grade students to make real-world connections with their Latin American social studies curriculum. Now, if you're representing the school district, that's a very good fact, and we'll get into that in just a little bit. But there are some other facts. For example, one of the plaintiff's children's teacher emailed parents encouraging participation in the supply drive. And I should note, this came from the teacher's public school email account. And the email requested supplies and monetary donations, stating, make checks payable directly to the school. Now, there are a lot of other facts that I don't get into. For example, some of the money was used to buy beads for prayer bands that were going to be disseminated. Another fact, the high school newspaper used a month of its profits to help fund the trip. So essentially what happened here, this district court, federal district court in Colorado, applied what's called the Lemon test. This is a 1971 Supreme Court decision in a case called Lemon v. Kurtzman. And that's why I wanted to discuss this case, because the Lemon test is really the gold standard for how courts will consider issues that take place from government actors that brush up against religion. And essentially what the Lemon case talks about is what it calls, and I wouldn't use this terminology, but what it calls the 3 main evils against which the Establishment Clause was intended to afford protection. First is sponsorship of religious activity. Second is financial support of that activity. And third is active involvement of the sovereign. And I should note, for any administrators of public schools out there, in this case, you are the sovereign. Remember, if you are working for a state university or college, you are a state actor, a government actor. So in these cases, when we talk about the government taking an action, keep in mind that that involves you. So the Supreme Court created what's called the Lemon test. It's a 3-pronged test. Anybody who's been to law school will have had their fill of these 3-pronged tests. And it essentially says that a government action does not violate the Establishment Clause. That is, a government action is constitutional so long as, number 1, it has a secular purpose, a non-religious purpose. Number 2, it doesn't have the principal or primary effect of advancing or inhibiting religion. It could be a specific religion or all religion. And number 3, it does not foster a, quote, excessive entanglement. Now, there has been decades of litigation about what excessive entanglement means, and we'll get into that in a little bit. But essentially, a government action violates the Establishment Clause if it fails to satisfy any of these 3 prongs. So it's not just, you don't have to do 1 or 2, you have to satisfy all 3. So let's see how it played out here. As far as the purpose prong, the good news is courts have stated that they should not engage in judicial psychoanalysis. They will give state actors, and that includes higher education actors, the benefit of the doubt. Their role is limited to finding out whether the whether the given purpose is a sham secular purpose. And they didn't here. The defendants, the school district, won on the purpose prong. But they did not win on the effect prong. They failed on that. The court considered whether the practice conveyed a message of endorsement or disapproval of religion. It doesn't have to be monetary. Symbolic benefits are enough. And the test is whether a reasonable observer would perceive the government to be acting neutrally. And the court here said no. The very concept of a mission trip has religious intimations, and the Guatemala mission trip was overtly religious. So the defendants failed on the effect prong. Now I should note, they also failed on the entanglement prong. This is a lot hazier. It's got some gray area. But basically it prohibits contacts between the government and religion if they are so extensive that they have the effect of advancing or inhibiting religion. Here they said yes, you're getting government actors entangled with a religious trip. So the conclusion is the court holds that the constitutional rights of Ms. Zoe and her son, guaranteed by the First Amendment, were violated. So what happened? The parties were directed to meet and confer, attempt to reach an agreement on the form of the judgment, and I will note that although there were no monetary damages, it did include reasonable amounts of costs and attorney's fees. That's often what we see in these cases. They aren't big dollar cases, but they take a lot of time. They take a lot of legal fees. And often, if the school, the university, the college is on the losing end of it, they're often ordered to pay the other party's costs or attorney's fees. So what are the lessons learned? The good news is courts will always defer to a party's secular purpose, and that includes a secular purpose set forth by a college or university. But courts will bend over backwards to avoid state actors making decisions related to faith. So again, we're talking state actors, so this is limited to public colleges and universities, but consider in your policies, are any of your administrators asked to make decisions related to faith? For example, are they asked to say whether a student's actions or religious student organization's actions are related to that student or that group's sincerely held religious beliefs? If you are leaving that determination up to a state actor, a college administrator, that's going to be problematic. There's also a vast difference between actions that take place during school hours and those happening before or after classes. That gets a little hazier on the college campus because courts routinely acknowledge that education on campuses doesn't just occur in the classroom. It occurs in student organizations. It occurs in music and athletics and Greek life. So it's a little harder to determine what that means in college campuses. The questions that I would ask are essentially, is the campus sponsoring it, either through either financially or by making space or rooms available? And finally, beware of using public funds, and that includes correspondence from public accounts. If you're at a public school or university, your email that you send basically counts as using public funds. If you're using the office printer, using office ink or office paper, that can be seen as the use of public funds. So that's the end of the first case. Before we move on to the second, I got some great advice a few weeks ago that says, if you're giving this presentation, don't just throw a lot of text at the listeners, and I realize that's exactly what I've done. So I was advised to reward listeners with a nice break in the action. So here's a picture of an adorable baby hedgehog. We can take a second there before we move on. So let's move on. One of the issues that we see in colleges and universities more and more is this balance between discrimination or non-discrimination and civil liberties, particularly religious civil liberties. So what do we know at the outset? Public colleges and universities have a right to institute non-discrimination policies. So do private colleges and universities. Students have a right to the free exercise of their religion. Universities are in a tough spot when these two rights arguably conflict. Now again, private universities have a little more freedom. They're not in quite as tough a spot. But with public universities, you are a government actor. So it's very difficult to balance your right to institute non-discrimination with the free exercise rights of students. Before we jump into the cases, what do we know for sure? Number one, state colleges and universities are not enclaves immune from the sweep of the First Amendment. So your students have First Amendment rights. They don't give them up when they walk onto the campus. Number two, university programs that grant student organizations official registration or recognition create what's called limited public forums. You've probably heard about these. Oftentimes, when you are trying to determine whether you can allow or prohibit speech, courts will talk about what's called a limited public forum. If you are allowing for speech to take place, it is a public forum, and you must treat all speakers the same. Now, that's very, very elementary, but basically what the courts have all said is an official student organization policy does create a limited public forum. And finally, a public university cannot withhold student organization benefits from a group based on its religious perspective. If a public university is going to sanction student organizations, it must treat religious student organizations the same as non-religious student organizations. That was the Rosenberger versus University of Virginia case. That involved the denial of funds to print a newspaper that espoused the Christian views. And the court says, well, that's viewpoint discrimination. If you will use student funds to print some newspapers, but not use them to print newspapers espousing Christian views, that's clearly viewpoint discrimination and is a violation of the First Amendment. So we're going to jump right in to the first case, and if you've been in the business for a while, you may have heard about this one, Christian Legal Society versus Martinez. This was a Supreme Court decision in 2010, a 5-4 decision. The majority were the court's liberal justices, and the majority opinion was authored by Justice Ginsburg. So what happened? The Christian Legal Society filed suit against the University of California Hastings College of Law for violating its First Amendment rights. Why? Hastings failed to recognize Christian Legal Society, or CLS, as a registered student organization because it refused to amend its bylaws to comply with the university's non-discrimination policy. We've seen more and more of these cases pop up recently. This is kind of the premier U.S. Supreme Court case. So let's step back for a little bit. I'm guessing most of the people on this webinar have registered student organizations. And I'm guessing they're treated in roughly the same way. Here in Martinez, registered student organizations were officially recognized student groups. They could seek financial assistance through funds available from a student activity fee. They can use school channels to communicate with students. They can apply to use school facilities. There are others. For example, they can officially use the university's logo, but they also must comply with the university policies and regulations applying to college activities, organizations, and students. And Hastings had a non-discrimination policy. And for our purpose here, that non-discrimination policy included sexual orientation. It also says that the non-discrimination policy applies to Hastings-sponsored programs and activities. So there was no question that the non-discrimination policy covers sexual orientation, and no question that it covers the activities of RSOs. Now, at the outset, if you've ever read this decision, about half of it is an argument about whether Hastings policy is what's called an all-comers or accept all-comers policy. Hastings said it was. According to Hastings, school-approved groups must allow any student to participate, become a member, or seek leadership positions in the organization regardless of her status or beliefs. That's what's called an accept all comers, or what I'll refer to as an all comers policy. The argument that's always thrown out in the court cases is, well, under an all comers policy, college Democrats have to allow Republicans, and college Republicans have to allow Democrats. It's obviously more intense than that, but that's kind of the example that's thrown out here. The dissent disagreed. I'm not going to get into the back and forth about it. The dissent argued that Hastings really didn't have an all comers policy, they just said they did. But ultimately, the court said, well, the parties agreed to it, so for their considerations, they assumed that an all-comers policy was in place. So that's what we're going to assume as well. So CLS had a statement of faith. All CLS chapters must adopt bylaws that require members and officers to sign the statement of faith and to conduct their lives in accord with prescribed principles, one of which being sexual activity should not occur outside of marriage between a man and a woman, and they exclude anyone who engages in, quote, unrepentant homosexual conduct. That came straight from the statement of faith of CLS. Now, in this case, the school rejected CLS's application because its bylaws did not comply with the non-discrimination policy, because in the university's view, CLS barred students based on religion and based on sexual orientation. CLS formally requested an exemption from the non-discrimination policy. By my understanding, that was the first time that had happened on Hastings campus. But Hastings declined to grant one. So what happened? CLS did not obtain RSO status. Now that did not mean that CLS did not exist. It operated independently. It held weekly Bible studies and invited students to church services and hosted lectures and hosted dinners and various social activities. But by not being an RSO, it could not apply for student funds. It couldn't use certain school-sanctioned methods of correspondence and on and on. So there's no question that it continued to operate, but it did not have the benefits of other registered student organizations. So here's a legal issue that the Supreme Court considered. May a public law school, and this has been expanded to any public college or university, but may a public law school condition its official recognition of a student group and the attendant use of school funds and facilities on the organization's agreement to open eligibility for membership and leadership to all students? Now CLS says no. An all-comers policy violates its First Amendment rights. They said, we're on pain of relinquishing the advantages of recognition, you are forcing us to accept members who do not share our core beliefs about religion and sexual orientation. Obviously, the university disagreed. It said CLS seeks special dispensation from an across-the-board open access requirement. And the university further went on to state that their open access requirement was designed to further reasonable educational purposes. The majority here said that courts have permitted restrictions on access to a limited public forum with one key caveat. Any access barrier must be reasonable and viewpoint neutral. Now, if you have had situations on regulating speech on your campus, you've probably heard these terms before. Any access barriers must be reasonable and viewpoint neutral. These impact the religious clauses of the First Amendment the same as they would impact, for example, the freedoms of speech inherent in the First Amendment. There was also a focus on the difference between requiring action and withholding benefits. The court basically said it is more severe to require a group to do something it does not believe in than it is to withhold benefits because it would not do something such as signing a non-discrimination policy. And ultimately, the finding was compliance with Hastings' all-comers policy is, in fact, a reasonable, viewpoint-neutral condition on access to the student organization forum. So the finding was with the university. The university did not violate the Constitution in requiring CLS, the same as any other student organization, to choose between welcoming all students or foregoing the benefits of official recognition. This is a quote from the Ginsburg majority opinion. It says, CLS, it bears emphasis, seeks not parity with other organizations, but a preferential exemption from Hastings policy. The First Amendment shields CLS against state prohibition of the organization's expressive activity, however exclusionary that activity may be, but CLS enjoys no constitutional right to state subvention of its selectivity. So, what do we learn from the Martinez case? Again, good news. Courts are cautioned to resist substituting their own notions of sound educational policy for those of the school authorities which they review. And I will say we see this again and again and again in these cases. Judges realize that they are not educators. They are not administrators. So if a college says that it is doing something to advance some educational reason, the courts 99% of the time will agree with them. They also say that extracurricular programs are essential parts of the educational process. To my point earlier, learning doesn't just happen in the classroom. It happens in these RSOs as well. So here, again, we're dealing only with an all-comers policy. The court held up the all-comers policy because it helped a university police a non-discrimination policy without inquiring into an RSO's motivation for membership restriction. It encourages tolerance, cooperation, and learning among students. And this kind of pinpoints a difficult issue that courts deal with, and that is distinguishing between status and conduct. Oftentimes, groups will say, we do not want LGBTQ individuals in leadership, not because of their status, but because we disagree with their conduct. And here the court cited one of its earlier cases and said, well, we're we're not going to make that distinguish because a tax on wearing yarmulkes is a tax on Jews. The status and the conduct are basically one and the same. One of the issues that was also addressed is this: does a policy require a student to fund a group that would reject the student as a member? Here there was some discussion about an LGBTQ individual who had to pay into a student activity fee and have a portion of that fee go to an organization that basically campaigned against LGBTQ rights. And here they said that is an okay thing for a student organization to do. And in fact, you have to treat that organization the same as any other organization. But it's more problematic when that student is not only funding that organization, but is then restricted from participating in that organization. Here, an all-comers policy avoids that. The court also dismissed the concern of a hostile takeover. I actually testified recently in the Missouri House about a bill that I'm going to be talking about later, and this issue came up. There it was, what if a rogue group of Presbyterians invaded the Baptist Student Association to take over? And Justice Ginsburg talks about that and makes the first legal argument is essentially, come on, that's unlikely. We don't see it happening. There's no evidence that it's happening. Obviously, tell me if that's different on your campuses. I'd be curious about that. But also, this is an important caveat, RSOs may condition eligibility on neutral requirements, attendance, payment of dues. If you want to limit leadership, you can limit leadership to people who have been involved in the organization, for example, for 2 or 3 years. You can limit leadership to people who pay dues. That's all fine. Those are all neutral requirements. Now, the last thing that I will say is our court looks very different now than it did in 2010. A third of the court has changed. You've seen Justice Kagan replace Justice Stevens. That shouldn't make much of a difference. And I'll note here, the 5 justices that are, I guess, in dark color here, Stevens, Kennedy, Ginsburg, Breyer, and Sotomayor, they were the majority in this decision. So Justice Kagan replacing Justice Stevens probably doesn't make much of a difference. Justice Gorsuch replacing Justice Scalia, they're probably going to vote the same way. Here's the kicker. Justice Kavanaugh replacing Justice Kennedy. Justice Kennedy was always the swing vote on these, and we don't really have a ton of information on how Justice Kavanaugh would rule in a case like this. Part of the reason why I think we are seeing a huge uptick in litigation involving these issues is because people see a very different Supreme Court, and people see a court that may rule differently now than they would have ruled in 2010. So that's case number 2. Let's all take a break and enjoy this picture of an adorable baby deer. Before we move on to case number 3, this is a very recent one, Business Leaders in Christ versus the University of Iowa. There was a decision in this case that was just handed down in February of this year. This case is currently on appeal. So a lot of this is in flux. But I think this case does a great job of basically explaining how the Martinez case is playing out in colleges and universities that do not have an all-comers policy. So what happened in this case? Business Leaders in Christ, or BLINK, which is a great acronym, claims the University of Iowa violated its First Amendment rights through the application of its non-discrimination policy. Now what you need to know is BLINK believes homosexual relationships are outside of God's design, and every person should embrace, not reject, their God-given sex. Those are some key facts here. The defendants were the university, the dean of students, the assistant dean of students, and the director of the Iowa Memorial Union, which, as I understand it, oversees RSOs. The University of Iowa does have a human rights policy. I've put some of it up here, but it's important to note that human rights policy includes protections for both sexual orientation and gender identity, and there was no argument that the human rights policy did not apply to the actions of RSOs. Now again, why is this different than Martinez? The University of Iowa does not have an all-comers policy. This is language that came from the briefing in the case. It's the policy of the university that all RSOs be able to exercise free choice as members on the basis of their merits. And the university acknowledges the interest of students to organize and associate with like-minded students. The university approves RSOs that require members to subscribe to their missions. Now, I will note that there's nothing wrong with this, and the court, in fact, said that this is absolutely valid. This policy is equally as valid as an all-comers policy, and the court will defer to the university or college leadership in which policy they want to use. Here's the rub. According to the university, RSOs must be open to all students without regard to the protected traits in the human rights policy. That is, you can require members to subscribe to their missions, and you can limit leadership to like-minded students as long as it does not violate the traits in the human rights policy that were a slide or two back. But here was the argument that Blink made. If you look at the University of Iowa, there are a number of RSOs that may arguably be in violation of that policy. Love Works requires leaders to sign a gay-affirming statement of Christian faith. 24/7 requires leaders to abstain from sexual conduct outside of, quote, traditional marriage. House of Lord interviews applicants to maintain a space for black, queer individuals and or the support thereof. The Chinese Students and Scholars Association is limited to, you guessed it, Chinese students and scholars. And the Hawkapellas is a female a cappella group. And I absolutely love the name, Hawkapellas. So essentially the university acknowledged that some RSOs continue for reasons which support the university's educational mission and the social purposes of the forum. For example, some groups continue because they provide a safe space for minorities which have historically been the victims of discrimination. So what happened in this case? A student interviewed with Blink's president to discuss serving on the executive board, and during that interview, the student revealed he thought he was gay. The board eventually concluded that the student disagreed with Blink's faith and could not serve in leadership, and the student, of course, filed a complaint with the university. So what happened? The university compliance coordinator conducted an investigation, and the coordinator concluded that Blink made a decision based on sexual orientation, in violation of the non-discrimination policy, I should state. Blink appealed. They had a meeting with the associate dean and the director of the Iowa Memorial Union, and it appears from the record that it escalated fairly quickly. All counsel was present at that meeting. The university essentially explained that the group may require leaders to abstain from extramarital sex, but only if the requirement was applicable to all. And they agreed that if Blink detailed its beliefs in the Constitution, it might resolve some concerns. Ultimately, Blink made some changes, which the university rejected. So Blink appealed again to the Dean of Students, who confirmed that the Statement of Faith violated the human rights policy because it disqualified individuals from leadership based on sexual orientation and gender identity. Now, as this was going on, the university reviewed all of its RSO's constitutions for compliance with the human rights policy, and a few dozen groups were deregistered. However, many of the RSOs we just discussed, House of Lord, Hawkapellas, Love Works, the Chinese Students and Scholars Association, continued to remain registered. I should note, this was not a Supreme Court case. This is currently before a federal district court in the Southern District of Iowa. And in that case, the analysis went as such. All parties agreed, yes, the university had created a limited public forum, and the First Amendment rights that applied to limited public forum would apply here. And there was an agreement that if a state university creates a limited public forum for speech, it may not discriminate against speech on the basis of viewpoint. Now, again, that's pretty elementary when we're considering constitutional issues on college campuses. So the consideration here was, are any access barriers, that is the non-discrimination policy or the human rights policy, are they reasonable and are they viewpoint neutral? Here's what happened. The court found that the restrictions on access based on the human rights policy were reasonable in light of the intended purpose of the forum. The human rights policy is viewpoint neutral as written. And in fact, the court said that a human rights policy like this is a good thing to have. They did not quibble with that. But the human rights policy was not neutral as applied because the university did not apply it uniformly. And based on that, and references to these other organizations, Blink established a, quote, pattern of unlawful favoritism. So what happened? The university was ordered to pay nominal damages of $1 and was prohibited from enforcing the human rights policy against Blink, provided two things. Number one, Blink does not change its statement of faith. And number two, the university continues to allow other RSOs exceptions to the human rights policy. Now, like I said, this is currently on appeal. Blink appealed, and this is the words of their counsel, in light of continued official statements by the university that its policies would continue to exclude religious student groups. Now again, that is language coming from Blink's attorneys, so take that as such. What are the lessons learned here? Now my guess is for a lot of universities, this sounds very familiar. A lot of universities that don't have all-comers policies do have non-discrimination or human rights policies. I would further guess that of those universities, there isn't a lot of policing done of how certain organizations operate and whether they are always in compliance with the human rights policy. The court acknowledged this was an unusual case, a difficult case, and a close call. There was no argument that the University of Iowa did anything wrong or that their process was inappropriate. And in fact, the court said that non-discrimination laws serve a compelling state interest of the highest order and generally do not violate the First Amendment. They further found that schools enjoy a significant measure of authority over student activities, but the university cannot interfere with speech to promote an approved message or discourage a favored one. So this was, although it involved the religious clauses of the First Amendment, the decision was mostly based on freedoms of speech. This is from the introduction to the case. This case underscores the importance of pursuing the best intentioned policies in an even-handed manner. The court notes that a policy other than an all-comers policy must be applied uniformly, even if it is distasteful to do so. My guess is if you have been in a public or private university for some time and you have to treat all student speech, student religious views, on and on and on in an even-handed manner, sometimes it may be distasteful to do so. However, it's important to do that. Allowing exceptions to a policy is not uniform, and any exceptions must be necessary to serve a compelling state interest and narrowly drawn to achieve that end. An example of that might be, for example, if a white supremacist wanted to join a student group, that white supremacist speech was protected, but a compelling state interest may be, for example, the safety of students, if there was a question about that. That is the third and the final of the cases that we are going to be discussing. So let's take a deep breath with a picture of a baby hippopotamus eating a salad. I hope you're enjoying these as much as I am. There are two very brief issues that I want to talk about before we wrap this up. The first is a lot of states are trying to enact legislation that addresses these very issues. And in fact, a few weeks ago I testified in front of the Missouri House Higher Education Committee on House Bill 837. That bill stated that public universities shall not deny a benefit to or discriminate against a religious student association based on a requirement that its leaders adhere to the association's sincerely held religious beliefs, and on and on and on. It actually creates a cause of action against the university for any violation or threatened violation. Now, I will say I testified against that not because, you know, I'm Switzerland here on whether that is right or wrong, but the issue that I had is, if you look at this, this is a bill that applies only to religious student associations, not any other student association, which to me raises a lot of questions with the Establishment Clause. I also worried that this might open the floodgates to litigation due to the entanglement issue, an excessive entanglement. I would not want to be the school administrator that had to determine whether an action was based on a student's sincerely held religious belief or not. And I'm guessing most of the people on here may not want to as well. So that bill, we're in our final week of the Missouri legislature. That bill probably will not pass, but we've seen a huge uptick in these bills. There were 3 or 4, I think, filed in 2013. It's grown. There were 22 bills filed just in 2019. Similar legislation has been passed in multiple states. Now, as far as I know, most of those pieces of legislation have not been challenged on their constitutionality, but you should be aware of any legislation in your state that's either coming through the pipeline or has been enacted. Because whether or not it's unconstitutional, if it's on the books, you will need to comply with it. The last thing I'll talk about was earlier this month, the Trump administration finalized new conscience rules, making it easier for healthcare workers to refuse to provide care that violates their religious or moral beliefs. The one thing I want to note here is those conscience rules apply to professors, to residents, and to students. So if you are in a public university that has a medical center or a medical school, for example, you should try to stay abreast of these conscience rules, and we can try to pump out that information when it comes out. Now, I will say there's already the threat of a lawsuit from the California Attorney General. My guess is there will be a number of other lawsuits coming in the future. So keep aware of that. But for now, if your university has a medical college, you should be aware that changes may be coming. I can do a few final takeaways, and then we can open it up if there are any questions. So again, nothing's going to be new on these slides, but essentially, if you take an action, and this is geared solely to public colleges and universities, if you take an action, and that could include a policy or procedure that's implemented that might brush up against religious freedoms or the free exercise of religion, consider three things. Do you have a secular purpose? Is the primary effect advancing or inhibiting religion? And does it foster excessive entanglement? Are you going to put university or college administrators in a position where they're going to have to make decisions based on faith? If so, it may not survive judicial scrutiny. If you allow for speech, you cannot withhold benefits from a group based on its religious perspectives. That's fairly elementary. So what is the answer? Am I telling you that you should apply an all-comers policy? Am I telling you your current policy is fine and a non-discrimination policy applying to it is fine? There are some schools that are looking at deregulating student groups to avoid this litigation. Is that the answer? The answer is all of these are fine in some ways, and changing them sometimes can be poking a sleeping bear. That actually happened at Vanderbilt in 2010 after the Martinez decision. They went to an all-comers policy, and although they were not in a lawsuit that I'm aware of, there was a lot of difficult PR, not only public relations, but also issues with funders. So what is the answer? Whatever you have can be done constitutionally. It's important, though, to be aware of it, to be clear, and to apply it uniformly. So again, be clear about your policy. It should be easy to find on your website. Training is essential. Now, I will tell you, in researching this, in many of your colleges and universities, that policy is anything but clear. I spent a lot of time on your website, and it was very difficult to find these policies. It's important to make those as clear as possible and to train your RSOs. And the policy must be applied uniformly. Be clear about what's permitted and is not. And again, consider whether a student is funding a group that would not allow that student to serve as a leader. Be aware of state legislation. Be aware of using public funds, including correspondence from your public email account. And if possible, avoid state actors making decisions related to faith. The final takeaway that I have is, if a complaint is raised, assume that litigation will follow, particularly if you see some of the groups that we've talked about. Assume, number one, all written communication that you have may be discoverable. Now, what you should do is, obviously, my hope is you have procedures in place for investigations. Follow those to a T. Go through and document them just as your policies and procedures state. Any extraneous written communication should be minimal. Assume that it will be discoverable. If you have any kind of a review or a meeting with student organization, make sure that all parties are as knowledgeable as possible about the policy. Don't send deans of students in to discuss policies of which they are not aware. That can be the cause of a lot of trouble. And finally, get your legal counsel involved in an early stage. I know it's the attorney telling you to hire an attorney, but whether it's your in-house counsel or us or other outside counsel, if you have these complaints raised, get counsel involved earlier in that process. You may also want to look proactively at your RSO bylaws and constitutions to see where you are. That might help stave off some litigation. And obviously, we're happy to help with that. And my guess is in-house counsel probably will be as well. Those are my takeaways. You guys were great. I assume you were great. I can't see you. So we will move forward to a few questions. I know I've seen a few come in.
All right, Jordan. So one question that we've got throughout the presentation is, do the holdings in the AHA or Martinez have any implications on private institutions?
The answer is yes and no, which is a very lawyerly answer, yeah. I know. The First Amendment restrictions that the Supreme Court considered in Martinez and that the district courts in Colorado and in Iowa that we talked about considered don't apply to private school students in the same way they apply to public school students. What private schools will have to look at is to make sure, number one, that they are not violating any federal or state statutes. And those change state to state. So be aware of the educational statutes that apply in your state. The biggest thing that I will say is if your private college or university has policies in place, that is fertile ground for litigation if you are not following those. So that's why I went through and said that a lot of these public school cases are important, because what I see is oftentimes private colleges and universities will actually adopt pretty much the same guarantees on free speech and freedom of religion that public universities do. If your private college or university is doing that, you need to abide by those. And if they're doing something else, you need to abide by that as well. So ultimately, courts often will apply very similar reviews of how private schools are acting, but instead of looking at the Constitution, they're going to look at those universities' own policies. So know them backwards and forwards and make sure that they are applied even-handedly.
And another question that we got early on was, it was when we were talking about the Establishment Clause. And so we got a question, what about Christmas trees? And at least my recollection of the case law on Christmas trees are, it depends the other symbols that you have associated with it. So if you have the Christmas tree paired with other non-secular symbols, holiday symbols that are, Santa Claus, reindeer, those type of things, it's more likely that it would not be considered as entangling with religion, versus if you paired that obviously with a nativity scene or other more common religious symbols. But do you have anything to add to that?
Yeah, to your point, it's going to be fact intensive. If one professor puts up a Christmas tree and another professor puts up something else, that's fine. If you have a 100-foot Christmas tree in the middle of the quad, that's going to be a lot more difficult. Yeah. And a court may look and say, well, we're venturing into a potential violation of the Establishment Clause there.
And we also received another question, and it's about what constraints do private institutions have with respect to student organizations that are limited to a particular race or ethnic group?
It's a really good question, and it's a really difficult question. So the biggest thing that I would say is look at, whether it's a public or private institution, look at your policies. If you have an all-comers policy, then any student should be allowed. If you do not, then it could be more problematic. For example, when I was in law school, we had the Blackwell Students Association, we had the Women's Legal Society, we had an Asian American Law Student Association. Now, technically, limiting membership to those specific traits, be they race, national origin, or gender, could be a violation of the university's non-discrimination policy. Again, it may be distasteful to tell those organizations that they can't not limit the membership, but certainly that's what we're seeing. And that's what we saw the court bending over backwards to do in the University of Iowa case, saying, hey, even if you're applying these even-handedly, or even if you're doing this with the best of intentions, you have to apply them even-handedly. And sometimes that can be distasteful. And here I think not a lot of people are going to say that those type of organizations should be forced to open themselves to everybody, but that's certainly where the cases are heading. Oh, yeah.
Well, can you just, we received another question. Can you discuss chapels on public university property funded by donations?
I can discuss it. I will discuss it with the caveat that I have not read many cases about this, so this is the gospel according to Jordan. But generally, what I would say is, there are a number of public universities that have churches of various denominations associated on property, and usually that's not going to be a problem. It may be more problematic, for example, if there is a chapel or a house of worship on campus and, for example, classes are being held there. Mandatory student activities are being held there. That's where you get into more problems. But generally, having houses of worship on college campuses isn't a problem. The only issue, again, would be as long as it's applied even-handedly. If you allow one denomination to have a chapel but not another denomination for whatever reason, that's when you may venture into possible litigation and some problems.
I've got another good question, and this will probably our last one here today. But this is a good scenario, I think, for us to talk about. What if a public university co-hosts an event with an off-campus organization that traditionally incorporates lots of prayer, for instance, an annual MLK banquet, where maybe there's a prayer or benediction during the service. It's held on campus, but on a day the school is closed. But the school does fund the event, or at least part of the event.
That is a great law school final exam question.
I feel like there's my torch final.
There's a lot of issue spotting going on there. What I would say there is you're probably going to look at the limit test. Is there a secular purpose here? Arguably, for example, an annual MLK banquet? Probably. Mm-hmm. Does it have the principal or primary effect of advancing or inhibiting religion? That's going to be the key. It'll probably be fact-intensive, but my guess is the answer would be that would be okay. And it probably isn't going to foster excessive entanglement. Now, if it was happening during the school day, if there were more than just a few student funds going to that, if, for example, attendance was mandatory for students and it was held where there were prayers of a certain denomination, that's where you may get into more problems. But generally, the less entanglement, the more likely it's going to be. Now, I'll note that issues like that are fairly common. Mm-hmm. We don't see a lot of litigation, but we have seen an uptick. So those kind of annual events that have been going on for 10 or 20 or 30 years, we're seeing more and more they're getting challenged now.
And Jordan, this doesn't relate to that question at all, but just and this is a question that we received is, how would can a public university employ a chaplain? Or is that going to then, are we going to have issues with entanglement then? You're obviously funding a religious, maybe a clergy or someone to offer to work as a chaplain at the university that's a public university. Is that something that you would see as an issue?
That's a really good question. And I went to a private undergrad. We had a university chaplain, but although we were a United Methodist university or affiliated university, our chaplain actually presided over and had religious leaders of various different faiths.
Okay.
And that would be the fact. That's the research that I would do. If you are applying a chaplain, is that chaplain essentially only presiding over worship according to one religion or one denomination? In other words, are students being that want to obtain the services of the chaplain, mm-hmm. only getting that in one religious background? Okay. Some other issues may be, is it mandatory? You have, for example, classes where students are forced to go hear a sermon from the university chaplain. That's going to be more complicated. So again, I don't have a great answer there. Courts are going to apply the test that we discussed today, and it's going to be usually a fact-intensive inquiry. An excellent question, though.
Okay. Well, thank you for joining us for our program today. We hope the information provided was helpful for you and your organization. If you have not already, please click on the survey icon on the bottom of your screen to complete our short survey. Your feedback assists us in providing quality future programs. As a reminder, the program has been approved for Colorado, Illinois, Indiana, Iowa, Missouri, Nebraska, Tennessee, Texas, and Wisconsin continuing legal education credit. A recording of the webcast will be available tomorrow for watching and sharing. Once available, a link to the recording will be emailed to you along with a certificate of attendance. The recording will be available for 2 weeks. This concludes our webinar. Thank you, Jordan, and thank you all for attending today.
Thank you, everyone.